SJC-11661, Nesta, Monell, and others, v. Boston Pads, LLC, and others.
Good morning, Your Honors.
Wait, hold off for a minute. Okay, Attorney Schwab.
Good morning, Your Honors. May it please the Court, my name is Hillary Schwab. With me is Brant Cassavant, and we represent the plaintiffs' appellants in this matter. The Massachusetts Independent Contractor Statute, Chapter 149, Section 148B, must apply in the real estate industry. That's the only conclusion that can be drawn from the language of the relevant statutes, the history and timing of their enactments, and the purpose underlying the statutory schemes.
Let me ask you, in the real estate statute, the language that says that a salesman may be affiliated with a broker either as an employee or as an independent contractor, and may by agreement be paid as an outside salesperson on a commission-only basis. I have two questions on that. What does the language outside salesperson in that statute mean? And the second question is, can a salesman who's an employee be paid on a commission-only basis?
Yes, Your Honor. So as to the first question, an outside salesperson is, of course, not defined in the real estate statute, so principles of statutory construction dictate that you would have to go to other sections of the law where it is defined. That term is used in the wage laws to define a category of employees that may be exempt from overtime under Chapter 151. So an outside salesperson is a category of employee who may be exempt from overtime. The Massachusetts minimum wage laws and regulations do not expound prolifically on what constitutes an outside salesperson.
So it's outside salesperson, if I understand you correctly, you just said it's in the wage law, so minimum wage, it's not in the independent, it's not added to 148B.
It would be governed by 148B because 148B governs chapters 149 and 151.
51.
It says that right at the outset of section 148B. So under chapter 151, which does fall into the rubric of section 148B, there is an outside salesperson exemption from overtime, not from minimum wage, not from the Wage Act, but from overtime. And this court, or Massachusetts courts, would likely look to how that term has been used in the FLSA, which is another area in which outside salesperson is used, and the determination has to do with where the person does the work and how the person conducts their work, how much oversight and other issues along the employment relationship.
And you might have addressed this, and I'm just forgetting. I just interrupted you. Sorry.
As long as you get to my second question.
No, you go ahead. I'll get there. You go ahead.
Okay, so as to the second question on commission-only basis, the answer is yes. A commission-only basis is a method by which employees may be paid under the Massachusetts wage laws.
So you're representing people who are being paid on a commission-only basis, and you're saying they're employees, but you're saying that they're still entitled to the minimum wage. That's what I don't understand.
Well, so the commission-only pay structure, commissions are wages under the Wage Act, and a commission-only pay structure is a traditional way that employees may be paid if the requirements to do so are met. It is typical in the commission context that a commission-only employee may be paid a draw, a weekly or biweekly draw against those commissions to ensure that the minimum wage laws are met. And so we're not saying that if the requirements to do so are met, that the commission-only pay structure is not allowed. We're just saying that you have to abide by the other aspects of the wage laws, which include not just minimum wage, but also the requirement that improper deductions not be taken from pay.
So you're saying you can be paid by commission only, but no matter what, you have to be paid a minimum wage? So if your commissions you don't do so well, you don't make many sales, you still got to be paid minimum wage? Is that what you're saying?
We're saying that you can take a draw for the minimum wage against the commissions, and if at the end of the day the commissions that you make do not satisfy just a bare minimum of $8 an hour for your work, that yes, the income has to be supplemented.
So it's not commission only then? So commission only doesn't mean commission only?
Well, To be honest, this area, commission only is a way that employees are paid, and it's recognized in the FLSA and the wage laws that this is a method to pay employees. To be perfectly honest, there is not a whole lot of case law on how the commission-only pay structure should operate under the wage laws. So my interpretation is you still have to abide by the minimum wage laws, and I know that it's traditional in many industries to have a draw against commissions for your minimum wage, and that
The draw against commissions is to ensure minimum wage?
Yes,
Or is
to
it just
ensure-
a way of ensuring regular compensation so that you don't have to wait?
It would resolve both the issue in Section 148 of the Wage Act that requires timely biweekly payment of wages and a requirement of at least
But it's not
minimum wage.
necessary to provide for a draw. That's just something, it's an accommodation that some businesses do.
It is an open question whether that's necessary under the Wage Act and the Minimum Wage Act or not.
Why is it an open question?
Because the Minimum Wage Act provides that any employee has to be paid at least $8 an hour for every hour worked. But the Wage Act also recognizes that commissions are an acceptable method of paying employees. The law is silent on whether, for example, if you go 6 weeks without a commission and then earn a commission in the 7th week, whether you can be unpaid for those 6 weeks under the minimum wage laws, which do not contain any sort of exemption for commission employees. Whether you can go unpaid for 6 weeks and then in the 7th week be paid a commission that may or may not make up for that unpaid work. So,
Counsel, is there any circumstance under which a real estate salesperson could be an independent contractor? It's hard to see that
I
from
think
your
that
argument.
I think that question is sort of the crux of this case. I would say at the outset, in this case, it's an easier question because the controls and supervision instituted by Boston Pads go so far beyond what's required under the real estate laws and so far beyond what qualifies the agents as employees under 148B that you don't necessarily need to get there.
So who draws the line for control if the statute says that the broker is supposed to be responsible for everything? So why doesn't the broker get to decide the limits of the supervision?
Yes, so to answer your question more directly, Your Honor, this court could decide that in order to comply with the strictures of the real estate laws, a broker could not also comply with the requirements of Section 148B to be an independent contractor. And in that case, 148B would have to control, I would submit, and what I mean by that is that real estate companies would have to classify their agents as employees for purposes of the wage laws and for purposes of the wage laws only. And what that would mean is they have to comply with Chapter 149, they have to comply with Chapter 151. That does not mean that agents could not be independent contractors for purposes of taxes, for purposes of unemployment.
But the statute doesn't say they can be independent contractors for one purpose and not for another. I mean, where do you get that?
I get that from the fact that Section 87RR, the provision in the real estate laws that states that an agent can be an employee or an independent contractor, uses permissive language. It does not define the terms employee or independent contractor. So the court is required to look at other provisions of the statutory scheme to determine what those words mean. And in fact, in each different employment scheme, a different definition is adopted for employee or independent contractor. There's no definition in Section 87RR, but if you go to the wage laws, Section 148B defines it. If you go to the unemployment laws, there's an entirely different section that defines it. If you go to the tax code, there's a different section that defines it. If you go to the anti-discrimination statutes, courts have applied an entirely different definition. So it has always been the case that an individual can be an employee for one purpose and not another, depending on whether the individual satisfies the test under the particular relevant statutory scheme. And because Section 87RR speaks generally and permissively, it is consistent with the statutory language and purpose of both provisions to say, well, for Section 148B, which was enacted subsequent to Section 87RR, you've got to be an employee and you've got to satisfy the wage laws.
question I wanted to ask you before, and you may have addressed this, but the adding the outside salesperson piece was in 2010? Is that
That's
right?
correct.
Is it your position that adding that, and as you said, that term is used in the, you don't have to pay overtime, I think, is what you said, right?
If you're an outside salesperson, there's an overtime exemption,
Well,
correct?
but it references to the minimum wage law. Is it your point that that addition in 2010 by itself is just evidence of the fact that the legislature was contemplating that these need to be read together?
Yes, and what's further relevant is that in 2008, the legislature proposed an amendment that would have exempted the real estate industry from Section 148B.
Yes, I know, but often, I mean, those can go both ways, right?
Well,
It didn't
what's
pass.
significant about it here, I think, is two things. One, Governor Patrick vetoed that 2008 amendment, and he did so for the stated purpose that it would have exempted the real estate industry from Section 148B. 2 years later, when the legislature revisited it, they did not try again. They did not try to exempt the real estate industry from Section 148B, and instead, they instituted a provision that confirms that this is a way that employees are paid, and we recognize that agents could be employees, and this is a provision for how they could be paid under the wage laws. So yes, I think it's relevant that that outside salesperson term, which links to the minimum wage laws, was used. I think it's also important to look at the purpose underlying both statutes in attempting to reconcile them. And this court has stated repeatedly that both the wage laws and Section 148B are intended to provide strong statutory protection for employees and their right to wages. Recently, in the De Pianti versus Janpro case, the court was particularly interpreting Section 148B and made clear that it's a broad remedial statute entitled to liberal construction in favor of the workers. The legislature itself has chosen to put a special contract provision in the wage laws that states both that employers cannot exempt themselves from the requirements of the wage laws by special contract or, quote, by any other means.
Well, I mean, they're not exempting themselves. The question is whether the statute exempts them.
Well, the argument that a statute that does not contain any explicit exemption from the wage laws would exempt an entire
So
industry.
you're saying when the statute says can be paid on a commission-only basis, it doesn't mean it.
I am not saying that. I'm saying that when the statute does not say that the real estate industry is exempt from Section 148B, that means that the real estate industry is not exempt from 148B.
And so commission-only basis means something different in here than it would mean anywhere else.
The commission-only basis analysis would be the same here as for any other employment relationship under the wage laws where employees are paid on a commission-only basis. It comes up in the sales context all the time, and this court would have to decide, as it would for any other industry, whether a commission-only basis follows the wage laws or not.
Can you think of any other situation which another industry is regulated, like the real estate industry, and the statute that does regulate it contains language that specifically contemplates that a real estate salesman can be either an employee or an independent contractor?
I know that the real estate industry is certainly not the first to say that its entire industry relies on independent contractor classification, and were Section 148B to apply, the entire industry would be turned on its head.
I asked you specifically about the language of a
Yes,
statute.
no, I understand the question that you're asking, Your Honor, and there are other industries that are regulated that have statutory schemes that apply to them, but as to that specific language, employee or independent contractor, I cannot. However, the fact that that language is stated permissively and contains no definitions, whereas every other section that actually specifically deals with employment statutes contains its own definition of employee and independent contractor, I would submit indicates that that language means only that, depending on the purpose and depending on the relevant statutory scheme, if it meets the test for employee, it's an employee. If it meets the test for independent contractor, it's an independent contractor.
Is there any type of employment that is specifically exempt from 148B?
Yes,
I mean,
so,
I know you mentioned several sections that mention real estate, but it's not 148B. I mean,
no, so Section 148B provides right in its language that it may have, quote, exceptions as authorized. So it recognizes that it can exempt a particular industry or a particular type of employment. And there is an example that we cite in our brief of family child care providers, which it states right in the statute, are not employees of family child care systems, quote, under Section 148B of Chapter 149.
But couldn't the legislature have made any exemption by virtue of the real estate statute itself?
It could have done what it tried to do in 2008 and say, notwithstanding Section 148B, real estate agents can be independent contractors. It could have done that, but it did not do that. And in order to override the strong statutory protections of Section 148B, it would have had to do so explicitly. It had the opportunity to do so in 2010, and instead of doing that, it said, no, you're an employee, but you can be paid. You could be employees, but you could have to be paid on this outside salesperson, or can be paid as outside salespersons.
Thank you.
Thank you, Your Honors.
May it please the court. I'm Steve Perry. I represent the defendants' appellees. With me is Bob Kuttner. The conflict in this case is not just between the language of Section 87RR and the provisions of Section 148B, which would make every real estate agent in Massachusetts an employee. It's a conflict between that independent contractor statute 148B and the way the entire industry operates.
well, let me just stop you on your first premise. Why would it necessarily mean that every single real estate agent in the Commonwealth is an employee?
That's because, Your Honor, the provisions of 148B are a three-prong test. You have to meet all three prongs. And while the first prong, supervision, can be argued either way, we think clearly is inconsistent, that the degree of supervision is inconsistent with what's required to meet the first prong. But if you look at the second and third prong, the second prong is the agent must act outside the course of business of the broker, which is literally impossible because the agent has to work as part of the broker's business, and all the commissions have to flow through the broker, et cetera, as laid out in our brief. And the third prong has been construed to mean that the agent has to wear his own hat. And you can't do that. And his own hat has been construed to mean that you have to be able, as in the Coverall case, to be working for other clients. You're not allowed to do that. So under the way this court has interpreted those prongs, it's quite clear, and under the plain language of 148B, it's quite clear you can't be an independent contractor if that test is applied, as the lower court held, and as I think was virtually conceded in the oral argument earlier today. There was, in response to Justice Hines, there was no example given of how you would be able to comply with 148B and still be an independent contractor.
So if that means that the first question is that can these statutes be read in a harmonious way, you're saying everybody agrees no, they can't. Then the question is which one controls?
Yes, so let me go on with that question and say why is it that we have to conclude that 87RR controls? And that's the point I'm going to make about the conflict being not just between the statutes, but the way the industry operates and has been established and has operated for decades with the explicit authorization of the legislature through an entire statutory scheme that I'm going to run through real quickly. So first,
Can I
Yes.
ask you a question that goes to that in a way? I mean, the statute, the real estate statute provides for the possibility of either a real estate salesman being an employee or an independent contractor. So there must be some way of distinguishing in any particular situation which is which. And if you're not going to be able to use the independent contractor statute for that purpose, how do you distinguish between which real estate salesmen are employees and which real estate salesmen are independent contractors?
that's a good question, and here's how you do it. It's consistent with the state and federal tax treatment. The federal tax safe harbor statute provides that you will be considered to be an independent contractor and that the payments made to you will be considered business income and not wages. and state law adopts those provisions, provided some
But you're
requirements are
using
met.
the tax laws as the test, as opposed to, wasn't there something before the independent contractor statute? Wasn't there some kind of common law?
Yes. Before the, at the time that the statute was enacted, before 148B was enacted, a common law test was applied, and that was applied in the Savage case, although the Savage case did not take into account.
Savage, wasn't she a broker?
She was a broker, actually, not a salesperson, that's correct. But they applied, she was a broker, but she was affiliated with another broker, and Judge Cass applied a common law test and found that she was an independent contractor, and I think that gave the industry some solace as to salespeople being independent contractors under that same test. But what Justice Cass did not do in that case was look to the real estate statute and recognize that certain aspects of the relationship are governed by the real estate licensing laws, so that you have to exercise a certain degree of supervision and control. And in fact, the purpose of the real estate statute enacted in 1978 was to increase the amount of control and supervision that the brokers were exercising over their agents for the protection of the public without jeopardizing the independent contractor status. But there's a point I want to make that, following up on some questions asked earlier about why the construction taken by the plaintiff doesn't work. And this goes to some of the questions Justice Cordy was asking. All of the exemptions that we've run through in our brief, under which real estate agents are exempt from unemployment and from workers' compensation and can be classified for tax purposes.
Are they in always and everywhere exempt?
No, but here's when they are. That's what I want to get to. They're, in order to be exempt from those provisions, which the legislature intended to allow the industry to do, they have to be paid on a commission-only basis. So the express terms of the exemption from workers' comp and unemployment are, if you're a licensed salesman paid on a commission-only basis, then then whether you're an employee or not, you're outside of the workers' comp and unemployment system.
Was that done in 2010 as well?
No, that was done a long time ago.
Because the commission-only basis was added in 2010,
Yes,
wasn't it?
it was, and there's a reason for that, which I will also get to. But the starting point here is that these exemptions that the industry has benefited from that allow the industry to operate as it does require commission only for those exemptions, and the federal tax and state tax treatment under which you can be classified as an independent contractor for tax purposes also requires that you be paid substantially all your remuneration based on your productivity, which means commission only, or virtually commission only under tax regs. So if you were to take plaintiff's argument to its logical conclusion, and this was demonstrated earlier this morning, they're saying in 2004, at the latest, when 148B was enacted in its present form, you have tens of thousands of agents who were independent contractors at that time in Massachusetts, taking advantage of these exemptions I just laid out, paid on a commission-only basis. And the claim is that they all got converted overnight into employees who now have rights to minimum wages. And the point here is that the minimum wage statute, as of 2004, did not have any clear exemptions for outside salespeople who were selling real estate. It had a very ambiguous exemption. If you look at the definition of occupation in the minimum wage law, it states that people who engaged in outside sales who sell a product or products away from the office and do not make daily visits to the office are exempt from minimum wage. Well, imagine applying that to the real estate industry. Are these people selling products? Are they happening to go to the office every day? So did we have a situation where in 2004 the legislature mandated payment through 148B, silently mandated tens of thousands of people paid on a commission-only basis suddenly to be getting minimum wage? And what happens if that were the case? The whole system falls apart, because now when you're paying minimum wages, none of these people are eligible for the exemption from unemployment or for workers' comp or for the tax treatment, all of which the legislature intended them to have the benefit of. The whole system falls apart. That's how you know that 148B was not intended to override.
Intended to who to have the benefit of? The brokers?
The legislature intended the brokerage industry to be able to engage real estate agents without having to pay payroll taxes in the form of unemployment compensation and workers' comp, whether they were employees or independent contractors. But if they got minimum wages, those exemptions fly by the wayside.
Well, what do you, when Governor Patrick vetoed the language in 2008, in the budget amendments of 2008, what do you take that to mean? I mean, he made specific reference to this. I'm vetoing this because it would not apply the 148B to this industry, and I don't think that's the right way to go.
Yeah, that's definitely what Governor Patrick said. Now, of course, when you look at legislative intent, the governor's construction of what the law may be is not something that you defer to in any way. And what we do know is that the legislature in 2008 unanimously, I believe, when it adopted that emergency statute, was trying to clarify a dormant.
But it didn't override that veto, right?
No, it didn't. But they were trying to clarify a dormant conflict. There'd never been a case like this, but at the time in 2008, you had a lot of attention focused on 148B. The legislature in the same session had mandated treble damages, as you all recall. And in the very same session they did that, they unanimously said that brokers aren't part of this. The governor vetoed it, so in 2010, the legislature came back and they adopted a different amendment, and this one was the exact same sentence that they used before. It kept in place the language that said you can be an independent contractor, didn't strike it, and the way it reads, it says you may be an independent contractor or employee, and they added and may. So the word "and" may indicates that you still may be an independent contractor. That's how they clarified it. Now, they also added.
I lost you.
Okay. The new language says you may be an independent contractor or employee, and you may be paid on a commission-only basis.
Right.
If you're not allowed to be an independent contractor, they wouldn't have said "and may." They were reiterating the old language.
But that you can be paid as an outside salesperson on a commission-only basis. So it's actually kind of puzzling what that phrase means. A salesman may be affiliated with a broker either as an employee or as an independent contractor, and may by agreement be paid as an outside salesperson on a commission-only basis. Does that refer only to employees? I mean, does that refer only to independent contractors? Does that refer to employees as well as independent contractors? Does it refer only to outside salespersons who are neither necessarily?
I think I can answer exactly what that means. It means in either event, whether you're an independent contractor or an employee, it's okay to pay you on a commission-only basis. What they're doing with that is if you happen to agree to classify your agent as an employee, they're closing that loophole that was in the minimum wage law where it didn't have a very clear exemption for outside sales. So now there's a clear exemption for outside salespeople in place, but it wasn't intended to make all agents employees. It was intended to allow the choice to continue.
So you could be an employee paid on a commission-only basis?
Yes, that's what the statute now says. And you probably could be before 2010 under that ambiguous exemption I ran through, but the plaintiffs obviously say, no, we weren't selling products and we were going to the office every day, we're not exempt. And the legislature never intended to expose the entire industry to massive minimum wage claims from 2004 to 2010 by transforming everybody into employees and giving them these claims that would have destroyed the whole system. I want to
So did you ever really figure out how it is that you tell the difference between a salesman who's an employee and a salesman who's an independent contractor? And I guess the question is, if one argument is that if you have the independent contractor statute prevail, then there will be no independent contractors that are real estate salesmen.
Right.
But it seems to me if you have the real estate statute prevail, you won't have any real estate salesmen who are anything but independent contractors.
Well, Your Honor, I think the first place you would look to define the relationship is keep in mind that under the federal tax and state tax provisions, you need to have a written agreement. So the first place you would look to see what the relationship is in the written agreement. Now, if you were concerned that there may be abuses of the relationship and that in some cases people were said to be independent contractors, but
Does your written agreement, or at least at least the language I read, uses the word employee all over the place?
There is in the record, and the court cited the independent contractor agreement that my client used, but our client did use employment all over the place, and that goes to a procedural point that I want to make, which is this case is going to decide for the entire industry, does 148B apply? Now, plaintiffs could have gone on after they lost on summary judgment and claimed we're employees by agreement. 148B has nothing to do with it. They had counts that would allow them to do that. They dismissed those counts with prejudice in order to take this appeal and agreed that they could not bring those claims unless this court said 148B applies. So at the time the judge entered summary judgment in my client's favor, he said, I'm not disturbing counts 2, 3, and 4, under which plaintiffs are making claims for minimum wages, overtime, and wage deductions.
As a contractual matter.
Well, they hadn't pleaded it that way, but if they wanted to make it as a contractual matter, they could have done so. They dismissed those with prejudice. It's not before the court. And so technically, the court does not have to decide in this case the question that Justice Lenk is reasonably asking, which is, well, if we don't, we hold this doesn't apply, what does? You don't actually have to reach that only because of the bizarre procedural status. However, my answer to that would be you would look first to the parties' agreement, but if you had to curb abuses and apply some test, it would have to be a test that didn't penalize the broker for supervising and controlling the agents, because that's what the legislature wants. It wants them to comply with the fair housing laws. It wants them to comply with all of this myriad of consumer protection regulations that we've cited in our brief. So you really don't want to put the broker in a position of having to not supervise their sales force in order to attain the benefit of the independent contractor status.
Counsel.